Hi, I'm JP Diener. I'm an attorney with Beresford Booth, a law firm here in the state of Washington. And today I'm going to talk to you about when and how to appeal a court decision. Uh, State courts and federal courts both have an appellate system that allows you to get review of a decision that you don't like at the lower court level. In the Washington state court system, you usually start at the superior or trial court level. Then you move to the Court of Appeals, and finally at the very top is the Supreme Court. The federal court system is very similar. You start with the trial court, which is called the district court at the federal level. Then again, the Court of Appeals and the Supreme Court. But again, you always start at the trial court level. And that's where you lay out all of your evidence. That's where you make all of your arguments. If you're having a trial, you put on your witnesses. Either the judge or the jury makes the final decision. And if you don't like the decision that the judge or the jury makes, then you may have the opportunity to go ahead and file an appeal. You get another court, another group of judges to look at what that decision was. It's our fail-safe system in the legal system. It is a way to make sure that, hey, everything was decided according to the law, that the facts that were presented actually support the decision that was ultimately made. And it helps achieve justice. No system is perfect, but having this appellate system is absolutely critical to ensure justice in our states. So what happens if you get a ruling at the trial court level that you don't like, you think is wrong, you think is either legally wrong or isn't supported by the evidence that you've presented? You go to the Court of Appeals. That's your first stop on the appellate journey. And that's usually where it begins and where it ends. The Court of Appeals will take two different types of appeal. They'll take appeals, they have to take appeals that are final orders and judgments. These are appeals that are done as a matter of right. They don't have to take any appeals that are not from a final order or judgment. So if you have an order that you don't like, but it doesn't actually decide your case, maybe it was an evidentiary ruling, or maybe it was a ruling on a summary judgment motion on just part of what the case is about. In that case, you have to ask the Court of Appeals to review your case. It's not a matter of right, and you have to file what's called a motion for discretionary review because the review is purely discretionary and up to the Court of Appeals. It's a longer process than just filing it as a matter of right because you have to wait for the Court of Appeals to actually determine that this is an appeal that they are willing to consider, even though it doesn't concern a final order or judgment. If the Court of Appeals elects to take your discretionary review, or if you have an appeal as a matter of right and you just file a notice of appeal, you don't have to file the motion for discretionary review in that instance. If the Court of Appeals takes on your appeal, once that appeal is accepted, the Court of Appeals will issue a perfection letter. That perfection letter will set out a series of dates that you have to abide by, and any party opposing you in your appeal has to abide by from start to finish of the appeal. The real first step, once that appeal has been accepted, is to put together a list of all the documents that you think the Court of Appeals should review and consider during the course of your appeal. This is a list of exhibits, witness statements, tangible things that you presented to the trial court that the trial court considered in the course of its decision that you are appealing. You put together that list, and that's called a designation of clerk's papers. So everything that the Court of Appeals that will review that you submitted originally at the trial court or that the other side submitted is called clerk's papers. That's how they're referred to from that point forward in the appeal. So you put your designation together. The other side, the side opposing you, has the opportunity to add to that list if they wish to have the court consider other documents. And once that's done, then you contact the court reporter and you arrange for the court reporter who was present at your hearing or your trial to put together a transcript of that hearing or trial. And to provide that transcript to the Court of Appeals. That's called the Statement of Arrangements. Then you're telling the Court of Appeals, hey, I've talked to the court reporter, we've worked it out, they're going to put together this transcript, they're going to file it with the Court of Appeals. That's really the first step, is that designation of clerk's papers and the Statement of Arrangement. Once the transcript has been finished by the clerk, by the court reporter, and provided to the clerk of the Court of Appeals. Once that happens, then the clock begins to run on your appeal brief. Okay. The appeal brief is your full argument. That is where you set out all of the facts that are relevant, all of your legal arguments, and explain where you think the trial court got it wrong, where the judge or the jury went wrong, what were the wrong decisions, and why were they wrong. This is usually a pretty extensive brief. It's several pages, at least probably 15 or 20 pages on the light side, and upwards of 40 or 50 pages for the heavier brief. So this is a very involved document that takes some time to prepare. Usually, you get 45 days once the court record has been submitted. You finish your initial brief. You file your initial appellate brief. Then the other side has 30 days to review your brief, file their own responsive brief. Again, this is their one bite at the apple. The opposing party has a chance to respond to everything that you said, make their own legal arguments, and tell the court, no, in fact, the trial court was correct, and this is why the trial court was correct. They then submit their brief, and then you, as the appellant, have another 30 days to file a responsive brief. This is called the reply brief, and you're responding to everything that the opposing party said in their responsive brief, right? So this is your reply. You're focused specifically on what your opponent said, and you're addressing and telling the court why that is wrong. You submit your reply brief, and at that point, the briefing is done. Everything is pretty much in the hands of the court. The Court of Appeals is made up of a panel of 3 judges. Now, the Court of Appeals itself, each division within Washington State, they have a bunch of different judges, but they select 3 at a time to hear cases. So you get your panel of 3 judges, you're notified who they are going to be, and they then tell you whether or not they want oral argument on the issues that you are appealing. They may just issue a decision. You or your attorney may not get to go to court to address the brief and argue it and answer questions from the Court of Appeals judges. They might just issue a written decision, and that's it. If they do not want oral argument, that written decision will be issued anywhere from 3 weeks to 3 months after that reply brief is filed. If they do want oral argument, they usually set oral argument 6 to 8 weeks out after that reply brief is filed. Then you have the oral argument, and oral argument mostly just consists of the judges asking specific questions. If they're hung up on a specific issue that they want more insight in from the attorneys, that's what happens during oral argument, and they just ask questions, and the attorneys get an opportunity to answer those questions. It's very short. It's 10 minutes per side at oral argument. You don't get a lot of time to talk. So, and they stick by those limitations pretty much perfectly. Once that's done, once the oral argument is concluded, you do not get a ruling right there. Most rulings, again, are going to be 3 to 3 months after that oral argument takes place. Some are a little bit sooner, but not much. And some can take longer. I've got appeals out there right now that I think we're pushing just past the 3-month mark. So you never really know exactly how long it is going to take. That Court of Appeals, those 3 judges get together, they decide on a ruling. One of them writes the ultimate decision. That decision may be published, meaning that possibly there's something in there that's created new law or clarified existing law. or it's unpublished, which means there's no new novel issues of law in there, but they've decided your case. Um, if you the results of a court of appeals decision can either be to totally affirm what the trial court did, meaning they say the trial court didn't do anything wrong, trial court was 100%, we agree. Okay, that's one option, and then you've lost your appeal in that instance. They may totally overturn what the trial court did. They may say this trial court made significant errors or an error that invalidates everything, and they just overturn what the trial court did and give the exact opposite result. Or, as is often happens, the court says, well, some or all of this was wrong, but it needs to go back. There needs to be more proceedings in front of the trial court. The trial court needs to look at these specific issues and make rulings or findings on these specific issues. So you may have to go back and try the entire case again. You may have to go back and just argue one small issue again in front of the trial court. But a remand, if the Court of Appeals does rule against the trial court, a remand is pretty often what happens, and it just adds to the length and the costs of the entire legal process in general. But that's typical. If you don't like what the Court of Appeals said, if you think the Court of Appeals was wrong, the Court of Appeals ruled against you, whether you were defending the appeal or bringing the appeal, your only other result, really, the only other thing you can do is go to the Supreme Court of Washington, or if you're in federal court, to the Supreme Court of the United States. The Supreme Court, whether it be in Washington, in any other state, or in the federal system, they rarely accept appeals from the Court of Appeals. They have to be very narrow, specific issues, usually issues involving criminal law or constitutional law. That's typically what the Supreme Court is going to take up. Unless they see something in the Court of Appeals decision that is just totally, totally off base and contradicts existing law, they won't take it. So once that ruling comes down from the Court of Appeals, chances are your appeals are done. You can try to get the Washington Supreme Court to take it, but the odds are against you. Statistically, they take a very small percentage of the cases that are petitioned before them. So, and then it's done. It's over at that point. Appeals can be highly complex. They can be on a bunch of different issues. I've seen appeals where the appellant raises 20 plus issues of things that they took exception with that the trial court did. They can involve very complex issues of law. Or they can be focused on as little as one simple issue, a very simple evidentiary issue, like this witness should not have been excluded, or this exhibit should have been allowed to be heard, or this exhibit was just too prejudicial and caused the jury to align against our side. So it can be one simple issue, or it can be a lot of different issues, something very, very complex. But regardless of that, having the right attorneys to assist you in the appeal process is absolutely critical, because it's so easy to make the wrong argument, miss a critical step in an appeal. And so really good, competent, experienced appellate representation is very, very important. And we at Beresford Booth stand ready to assist you on any appeal related to real estate litigation, trust and estate litigation, business litigation, and family law. We've been doing this for years and years. We have lots of experience amongst our attorneys, and we are happy to step in and assist you on your appeal. So feel free to reach out. Thank you.